GDPR was already implemented in April 2016, but the lawmakers have envisaged a 2-year transition period. So the new law will become effective in May 2018, and as of this date also the heavy fines will be applicable. We now see a lot of, actually the entire industry, looking around right and left, where's the law going, how to be compliant, etc. The law poses indeed a challenge to the smaller companies which lack a procedural maturity to the implementation of processes and the very formal and technical approach of the GDPR. Now, we also understand that the industry lives by the smaller, medium-sized companies and by the startups, which have a very flat organization, which haven't yet had the maturity to build up the processes as compared to Microsoft. So from this angle, we can indeed say that the smaller companies and the startups have additional issues to be compliant with the GDPR, but it's also these smaller companies which actually are the innovation drivers and which will certainly come up with new ways how to be, also on a technical level, how to be compliant with the GDPR. So overall, I would say that the entire industry will gain and make a huge leap forward after it has really understood how to be compliant with the GDPR. On a higher level, we must understand that the topic of data protection is extremely difficult, but it will actually increase its difficulty. I say this because there is a very clear overlap between data protection and cybersecurity, or information security, how we also call it. And we will see an increase, and we already see nowadays an increase of cybersecurity attacks worldwide. Now, with the cybersecurity attack, you're obviously also incompliant with the GDPR. And therefore, this is a totally new realm of law which we first need to explore. What is the liability of a company which suffers a cybersecurity attack? So I don't think that we will see less fines for being incompliant with the data protection laws, but actually more in context of cybersecurity laws. We need to understand two things. The first thing being that we need to understand that we're the owners of our data, and that we are the guardians of our data. The second thing is that CTOs, internally in companies, CTOs, lawyers, CISOs, Chief Information Security Officers, need to work hand in hand to implement changes to the network, to the systems, to the processes, to be compliant with the law. CTOs need to understand that they cannot decide themselves how to do certain things. They need to clear those things cross-functionally with information experts and lawyers. I do not expect big fines against smaller and medium-sized companies as well as the startups, as long as they do not intentionally breach the GDPR. Some insiders, and this is perhaps a bit sarcastic, have actually called the GDPR an anti-WhatsApp, anti-Facebook, anti-Google law. I cannot comment much on this, but what we can draw from this is that certainly a dominant player in an industry, in a market, is much more affected by the GDPR than a smaller niche player. Well, the topic of data protection was actually a very interesting topic, mostly for lawyers. I perhaps shouldn't say this being a lawyer myself, but lawyers got very busy about implementing the GDPR. There are other topics in the telecom industry which apply and which are important to understand, because there's a lot of changing going on. One very important aspect is the relevance between the classical telecommunication service providers and the OTTs. We have a framework which partially captures the classical telecommunication service providers, but doesn't capture the others. Now, the others do not fall under the classical set of regulation, but provide similar service. And this is a challenge for us, for the industry, which we need to find a better understanding for.